Okay, guys, in preparation for exam number 10, which will be a 200 question exam, I'm making 4 videos. The first video is going to concentrate on material dealing with juvenile offenders that you'll be covering soon. There's about 40 plus questions related to that. Second section is going to be related to driving. There'll be 20 some odd questions there, I believe. Then the third video will deal with patrol and also radio communication. And then the fourth video, I'll break that down into deaf and hard of hearing, canine encounters, and then just some of the review questions to make out, again, 200 questions as we get closer to the end of the academy, where you will be taking not only the academy final, but also the TCO state exam, which will be on a Wednesday. I believe it's the 24th of August. This is the first of four videos here. And again, the questions in this video are going to concentrate on juvenile offenders, which is something that, quite honestly, we deal with more and more as police officers, the juvenile offenders, whether they are, of course, juveniles as far as victims, but more essentially juveniles who are committing crimes. But there's some other variety of questions related to juvenile-related topics in this section here. So let's go ahead and get started. TCO, again, I'm going to give you the TCO guide section number and then any applicable statutes. So you're going to make sure to look those up. And I strongly encourage you between now and the 24th of August, when you go over to Kilgore to take that final, that you really get into the applicable statutes that you, of course, have covered in your it seems like almost 6 months, at least 5+ months of the academy. So this is going to be TCO section or TCO guide 33.14. This is out of the family code. It's family code section 32.003, section A, paragraph 2A. A child who is at least what age, who is living apart from their parents and managing their own finances may consent to their own medical treatment. So at what age, if you are living apart from your parents and you are out on your own, and there are some that are out there legitimately at this age, what is that age? Is it 15, 16, 17, or 10? So be aware of that age. And again, think about the age that's required, or that you typically are going to get a driver's license. And so think about that age there. It's 33.14 of the TCO guide, and again, family code section 32.003 A2A. 33.14 also of your T code. This is family code 32.001. Who can give consent to medical treatment for a child when you cannot find their parents, you cannot locate their parents, and that person is not given actual notice to the contrary? Can a brother or sister give it? Can anyone who the child lives, a cousin, an uncle, a roommate, or any relative for that matter, or is it limited to the grandparents? Who may give consent? Family code 32.001. Who may give consent if you can't find the parents and that person is not given actual notice to the contrary? 33.15 of the TCO guide, this is family code 262.007. You as a law enforcement officer during a criminal investigation that's related to a child's custody discovers that a child is a missing child and believe that a person may flee with or conceal the child shall do what? Okay, shall. So you are working an investigation. You find that there's a child here and that there's some question that this child is missing, and you have the belief that that person who has that child may flee or conceal that child. What shall you do? Shall you maintain a perimeter around the premises to prevent escape? Shall you immediately call for backup and Department of Human Services representative? Shall you notify child welfare immediately and secure a warrant? Or shall you take possession of the child and provide for delivery of the child as required by law. Again, should you take possession of the child and provide for the delivery of the child as required by law? 33.15 of the T Code, Family Code 262.007. Also 33.15 of the T Code, it's Code of Criminal Procedure, Section 69.009, Paragraph G. An officer, on determining the location of a child who is at high risk of harm or otherwise in danger, shall take possession of the child or deliver the child to a person entitled to possession of the child. If the person is not immediately available, what are you going to do? Must you deliver the child to a juvenile court? May you leave the child at the location, until juvenile court orders the child to be delivered to the Department of Protective and Regulatory Services. Must you obtain an order from the juvenile court determining whether the child is to be delivered, or shall you deliver or arrange for the child to be delivered to the Department of Protective and Regulatory Services? 33.2 of the T Code Guide, it's Family Code 51.02, Section 2. Be familiar with the definition of a child. A definition of a child. What is that definition of? And again, under the Family Code 51.022, or Paragraph 2, 5102, Paragraph 2. Is it 17 years of age or older and under 18 years of age who's allegedly or found to have engaged in delinquent conduct or conducting conduct indicating a need for supervision? Is it 10 years of age or older and 10 years of age or older and under 18 years of age, or is it 10 years of age or older and under 17 years of age? Again, I know most of y'all should probably have already that committed to memory. This is T Code 33.2. It's Family Code 51.02, Paragraph 15. Be familiar with the definition of a status offender. Status offender. Okay. 33.3, Family Code 51.03b. This is a scenario here. Officer Jones is dispatched to a theft call at Hobby Lobby. You probably catch my wife there shopping. Officer Jones contacts the loss prevention officer, who indicates that little Tommy there took $15.99, a $15.99 plastic model car kit from the store without paying for it. The loss prevention officer apprehended Tommy outside the store. Officer Jones, learns that Tommy's 13 years of age. What has he committed? Has he committed delinquent conduct? Is he a habitual felony conduct? Is it conduct indicating a need for supervision, or nothing? Tommy's too young. Again, of those choices, is he committed delinquent conduct, conduct indicating a need for supervision, habitual felony conduct, or nothing at all because he's too young? Conduct indicating a need for supervision. 33.3, staying with that, and again, Family Code 51.03, Paragraph A. This is another scenario. Next two questions actually are going to be scenarios. You're an officer working the patrol on the lake. You come in contact with little Johnny, who's operating his jet ski erratically. Go figure. Officer, you smell alcohol on Johnny. Really? And believes that he is intoxicated on a public lake. Officer Thomas, you, the officer, requests to see Johnny's driver's license. He tells you that he does not have a driver's license because he's only 14 years of age. Which of these levels has he basically committed? Delinquent conduct, conduct indicating a need for supervision, habitual felony conduct, or public intoxication? Delinquent conduct, conduct indicating a need for supervision, habitual felony conduct, or public intoxication. Again, delinquent conduct there. Think of what crimes he's committed, what punishment ranges of those crimes are, and that kind of should clue you in. Again, Family Code 51.03a. This is 33.4 of the T Code Guide. It's Family Code 51.095, Paragraph 2. You're walking through a parking lot and you notice a car with all the windows damaged. Upon closer inspection, it reveals a small pellet-type hole in the windows. Little 11-year-old Willie walks by you. You ask Willie, hey, you know what happened? And basically, Willie escorts you to the other side of the vehicle. He picks up a pellet gun and tells you that he shot the windows. Can you... okay, he's made a statement. I shot the windows, okay? You got 4 choices here. Can you use the statement only if it's recorded on your body camera? Can you use the statement for prosecution? Can you use the statement only if the child is taken before a magistrate and writes a confession? Or you can't use the statement for prosecution? Which is it? Again, this is a Family Code 095, paragraph 2. Obviously, yes, you can use that statement for prosecution. He's not in custody at the time, obviously. So there's no need for Miranda and all that kind of stuff. Next question, 33.2 of your T code guide. And sorry, guys, I keep on looking because I've got the door closed and Miss Grimes is not here to, just in case someone walks in. 33.2 of the T code guide. According to the definition listed in 51.02 paragraph 4 of the Family Code. Family Code 51.02, paragraph 4. Be familiar with the definition of a guardian. Okay? Be familiar with the definition of someone who would be a guardian. Okay? Sticking with that same area, it's 33.2 of the T Code. And it's 51.02, paragraph 9 of the Family Code. Be familiar with the definition of the word parent. Be aware of the definition of parent. And then also at 51.02 of the Family Code, it's paragraph 15 or section 15. It talks about status offenders, okay? It talks about status offenders. Which of these would not be a classification of status offender? A child who commits truancy, a child who is a runaway, a child who violates the juvenile curfew ordinance or order, or a child who's taken in protective custody. And if you remember, a status offender, status crimes are only crimes because of that person's age. Again, those of you that had any criminal justice in college probably talked about that at some point in time. A status offender, a status offense is only a crime because of the person's age. Curfew is that. Being a runaway, which may or may not be a crime in a particular jurisdiction. Truancy, possession of tobacco, those type of offenses. Even possession of alcohol by a minor is technically a status offense. So be familiar with those lists there and tell me which one is not one of those or follows under that definition. Okay, sticking with the Family Code again, 51.03, it's paragraph 2A. It's going to ask you some questions about examples of delinquent conduct, okay? Delinquent conduct. What would be an example of delinquent conduct? Being a runaway, being a truant, committing Class C theft, or committing conduct that violates an order of a municipal court that would constitute contempt of court. Out of those choices, which one would be an example of delinquent conduct? Again, runaway, truancy, Class C theft are all going to be, runaway and truancy are all going to be what? Status offenses, but that Class C theft, remember, go back to little Tommy there, who steals the model car at Hobby Lobby. That's conduct indicating a need for supervision. But which one is going to be an example of delinquent conduct? That's conduct that violates an order of a municipal court that would constitute contempt of court. Again, sticking with the Family Code. So you might want to study the Family Code with this test. This is 33.2 of the T Code guide. 51.02, section 3 of the Family Code. Be familiar with the definition of a custodian of a child. Who is considered to be, or who would be considered a custodian of a child? Okay. 33.4 of the T code, it's 51.09 of the family code. There's a quote, quoting a statute here, or part of a statute says, any right granted to a child by this title or by the Constitution or laws of the state or the United States may be waived in proceedings under this title if the waiver is made by the child and who? The parents, their guardian, the attorney for the child. Which of those would be, or A and B must be present. Who can waive it? The child and who else? Can the parents? Can the guardian? How about the attorney? How about the attorney? That's 51.09 of the family code. Sticking with the family code again, 51.095 of the family code. What must you do in order to take a written statement from a juvenile who is in custody? Okay. It seems difficult when you get into policing and you, whether as a uniformed officer or later on as a detective, it may seem like it's a very difficult process, but in actuality, it's really not. You do it a couple of times, it'll be just like questioning an adult. A couple of things have to happen there. Okay. So if you are going to take a written statement from a juvenile who is in custody, which means obviously Miranda is going to have to be included and waived. What are you going to have to do there according to 51.095 of the family code? Warn the child of his Miranda rights. The statement must lead to an undiscovered evidence, or take the child before a magistrate to be warned. And again, if you ever do that, and I know your instructors will clue you into this, you are going to want to take them to a magistrate. And those magistrates will have been pre-designated along with the location that you question. So those are some things you'll come across there eventually. Sticking with the family code, this is 33.5 of the 33.5 of the T code guide, but family code 52.025A. Who can qualify an area to be a juvenile processing office? Okay, just like I just was talking about. There's certain areas where you can question. There's also certain areas where you can process them. In other words, do paperwork, fingerprint them, and so forth. So this is the family code. It's 52.025 subsection A. Who can qualify that area to be designated as a juvenile processing office? A district court, the Texas Youth Commission, or the juvenile board. And again, common sense should tell you they're juvenile board. Sticking with 33.5 of the T code guide, family code 52.026 subsection A provides that the juvenile detention facility is located in the same county where the child is taken into custody. Who is responsible for transporting a child if he is not released to his parents? In other words, that the juvenile detention facility located in the same county where the child is taken into custody, who's responsible for transporting that child if he's not released to his parents? In other words, who takes him to that juvenile detention facility? A transport deputy, juvenile probation, the sheriff of the county, or the officer taking the child into custody, or the officer who's taking that custody of that child. Unless you work with the sheriff's office, you're a sheriff's deputy, obviously, that would apply to you. But if you're a Tyler PD or you're Longview PD and you're going to Gregg County's juvenile detention facility, you take them in custody, that's going to be your job. Unless again you release them to the parents. Sticking with 33.5 of the T code guide, this is 52.025D of the family code. Basically, what is the time limit that you can detain a juvenile in a juvenile processing office? Can you keep them there 2 hours? No longer than 2 hours, no longer than 5 hours, no longer than 6 hours, or up to 24 hours, or whenever the next school day is. So be familiar with what is the time limit there that you can take and detain them and essentially hold them in a juvenile processing area. 33.6 of the T code guide. This is a family code. It's section 58.0021B. When may you as an officer take a child's photograph for use in an investigation? Only if you have a court order, if they are needed for an investigation, you got to get the parents' written consent, or if you have probable cause to believe that the child has engaged in delinquent conduct and the photograph or photo of the child would be of material assistance in the investigation. In other words, when are you going to take a photograph of that child that you're going to need to use, whether it's in a lineup or some other type of investigation type. As long as you got probable cause to believe that the child has engaged in delinquent conduct, that photograph, taking the photograph of that child is going to give you material assistance in your investigation, then that's, of course, what you're doing. TCO Guide 33.7, Family Code 52.01, subsection A, paragraph 3, or paragraph A, subsection 3. You as a law enforcement officer may take the child into custody and issue a warning notice if there is probable cause to believe the child has engaged in what? Conduct that violates a condition of probation imposed by the juvenile court, delinquent conduct, conduct indicating a need for supervision, any penal code violation, or all of the above. In other words, can you issue a warning notice if there's probable cause to believe that they've engaged in conduct that violates a condition of probation imposed by the juvenile court, delinquent conduct, conduct indicating a need for supervision, a penal code violation, or all of the above? All of the above, of course, will probably be a good choice there. 33.12 of the T-Code Guide. This is Family Code 151.001, Section E, or Paragraph E. Which of these is not listed in the statutes as a person that may use corporal punishment for the reasonable discipline of a child? Which one of these is not listed in the statutes as a person that may use corporal punishment? Can a grandparent? Can a guardian of a child and who has the duty of control and reasonable discipline of the child? Or a principal of a child? A principal of a child. Which of the following is not listed in the statutes as a person that may use corporal punishment for the reasonable discipline of a child? Or, of course, there's all the above and none of the above. So take a look at that. 151.001E of the Family Code. This is 33.9 of the T-Code Guide. This is switching over to the Code of Criminal Procedure. Section 63.002A, the Missing Children and Missing Persons Information Clearinghouse is established where? Who houses the Missing Children and Missing Persons Information Clearinghouse here in Texas? Be familiar with that. Pretty easy when you think about state agencies there, that are, especially those that are listed. And it's not TCO, and it's not DHS, and it's not child welfare. So obviously, you take a look at the other choice there. 33.19, the T code. This is staying with the Code of Criminal Procedure. It's Chapter 63 or Article 63.003B. Missing Children and Missing Persons Information Clearinghouse is a central repository function, whose function is to do all the following except. Which of these is not one of the things that the Missing Persons Clearinghouse is a missing person clearinghouse function? To receive and maintain information on attempted child abductions in the state? Yeah, it's probably something they'll do. Collect, process, maintain, and disseminate accurate and complete information on missing children and missing persons? Yeah. Establish a system of intrastate communication of information related to missing children and missing persons? Probably so. Or route missing person information up through the municipal, county, state, and federal agencies? Take a look at that one there. You can kind of figure that one out pretty easily there. T-Code Guide 33.1. This is Family Code. Back to the Family Code again. It is Section 51.01. Basically, it's the purpose of Title III of the Juvenile Justice Code. It includes the following. Which one is not one of those purposes? To remove, where appropriate, the taint of criminality from children committing certain unlawful acts. To promote treatment, training, and rehabilitation that emphasizes the accountability and the responsibility of both the parent and the child for the child's conduct. To protect the welfare of the community and to control the commission of unlawful acts by children, or to provide punishment ranges in prison for criminal offenses. So which one of those is not included in Title III of the Juvenile Justice Code? This is 3310 on your T code guide, and this is the family code. It's section 54.01A. Which one of these is not a legal requirement for a detention hearing without a jury if a child is not released? So which one of these is not going to happen there, be one of the legal requirements for a detention hearing? The hearing shall be held promptly. Yeah, there's a time limit, pretty quickly. The hearing shall be held without witnesses to protect the identity of the child. The hearing shall be held not later than the second working day after the child is taken into custody. If a child is detained on a Friday or Saturday, then such detention hearing shall be held on the first working day after the child is taken into custody. Again, this is something that may seem complicated, but when working with children, you pretty much know you want to, again, hold a hearing promptly. Unlike somebody that's going to get put in jail and they may not see a judge for several days, weeks, for a detention hearing, you're going to do it pretty promptly there. It's going to, the hearing's not going to be held not later than the second working day after the child is taken into custody. So again, you have to figure in holidays in there. Of course, they already have an answer there dealing with Friday or Saturday. So if you arrest somebody Friday night, Saturday, or even Sunday, you're going to take it the next working day. If the next working day, which is a Monday, is a holiday, it would be held on Tuesday there. But the hearing shall be held without witnesses to protect the identity of the child. That is not included. Okay, that is not part of the legal requirements there. 3310 of the T code. This is Family Code 54.001. It talks about the detention hearing for a status offender or non-offender who's not been released administratively under Section 5302 shall be held before the what hour after the time the child arrived at the detention facility, excluding hours of a weekend or holiday. In other words, how many hours do you have for a status offender or non-offender who's been detained there? 8 hours, 12 hours, 24 hours, or 48 hours. Again, juveniles are going to have a pretty good time clock on there. 33.11 of the T code guide. This is Family Code 52.03A. Again, this is one of those where there's several answers. We're looking for which one is not or except. So a law enforcement officer who is authorized by this title in 52.03A to take a child into custody may dispose of the case of a child taken into custody or accused of a Class C misdemeanor other than a traffic offense without referral to juvenile court or charging the child in a court of competent criminal jurisdiction if the following conditions are met, except. Which one of these is not one of those conditions? Guidelines for such disposition have been adopted by the Juvenile Board of the county, which goes on to say in which the disposition is made. It's required by the section. The disposition is authorized by the guidelines. The officer makes a written report of the officer's disposition to the law enforcement agency identifying the child and specifically the grounds for believing that taking into custody or accusation of criminal conduct is authorized, or the officer cannot locate an available magistrate to hold a hearing under the guidelines. Obviously, that last one is not going to be part of that. So sticking with 3311 of your T code guide, this is Family Code 52.03C. A disposition authorized by that statute 52.03. Disposition without referral to court may involve which of the following? A brief conference with the child and his parent, guardian, or the custodian, so you need to know the definitions of that. Referral of a child and the child's parents, guardian, or custodian for services under Section 264.302 of the Family Code. Referral of a child to an agency other than the juvenile court, or all of the above. All of the above. Okay. 52.031A. Juvenile Board may establish a first offender program under 52.031 for the referral and disposition of children taken into custody or accused prior to the filling of a criminal charge for which of the following? Delinquent conduct classified as a capital felony. Delinquent conduct classified as a state jail felony and involves violence to a person. Class C misdemeanor, including a traffic offense, or Class C misdemeanor other than a traffic offense. A juvenile board may establish a first offender program under 52.031 for referral and disposition of a child taken into custody or accused prior to the filing of a criminal charge for which of the following: Class C misdemeanor other than a traffic charge. Sticking with 3311 of the TCO, it says Family Code 5204. A referral to the office or official designated by the juvenile board must be accompanied by or provided as quickly as possible after referral. Which of this is going to be got to be included? Okay, otherwise accompanied by your referral. All the information in the possession of the person or agency making the referral pertaining to the identity of the child and the child's address, the name and address of the parents, guardian, custodian, the names and address of any witnesses, and the child's present whereabouts. In other words, who has them in custody, and who's the parents, and who any witnesses are, and where they're at. Or a complete statement of the circumstances of the alleged delinquent conduct or conduct in need of supervision. Or, when applicable, a complete statement of the circumstances of taking the child into custody. Or, when referral is by an officer of a law enforcement agency, a complete statement of all prior contact with the child by officers of that law enforcement agency, or all of that has to accompany that referral. And again, if you ever deal with juveniles, and you will, it's not if, it's when you deal with juveniles, you're going to have to accompany all that stuff, whether it's a patrol officer or eventually as a detective. This is 3317 of your T code. This is this is the Code of Criminal Procedure, 15.27a. Again, this is one of those deals where we're talking about the referrals within hours. And a good answer to this question, obviously, is going to be very similar to your another hour, an hour within certain hours after the arrest or referral is made. If a law enforcement agency ascertains that an arrested person or a child referred to the office or official designated by the juvenile board is enrolled as a student in a public primary or secondary school, the head of the agency or a person designated by the head of the agency shall orally notify the superintendent or a person designated by the superintendent in the school district in which the student is enrolled of that arrest or referral within how many hours after the arrest or referral is made or before the next school day, whichever is earlier. Okay? So is it 12 hours, 24 hours, 36 hours, or 48 hours? And having done that as part of my duties as the sheriff's office when these statutes were created back several decades ago, once a juvenile was arrested, I had to notify them within 24 hours. And of course, the great ease now, even back then, was that we had the availability of email, and we could find out who the designated person was for whatever school this student or this arrested juvenile attended, and we can notify them within the appropriate 24 hours there. 3321 your TCO, it's Code of Criminal Procedure 63.011. On written request made by to a law enforcement agency or on the written request made to a law enforcement agency by a parent, foster parent, managing or possessory conservator, guardian of the person or the estate, or other court-appointed custodian of a child whose whereabouts are unknown, the law enforcement agency shall request from who information concerning the child that may aid the person making the request in the information or location of the child. In other words, agency shall request from the law enforcement agency's record division, the Texas Department of Health and Human Services clearinghouse, the Texas Child Protective Services clearinghouse, or the Missing Children's and Missing Persons Information clearinghouse. And again, missing children's and missing persons information. You don't know where they're at, their whereabouts are unknown. That's who you're going to want to call. 3321, again, your TCO, it's Code of Criminal Procedure 63.021A. There's kind of a three answers there. It's a answer, comma, or answer. On receipt of notification by law enforcement agency or the clearinghouse regarding a missing child under 11 years of age, the blank the blank or the blank shall maintain the child's records in its possession so that on receipt of a request regarding the child, they will be able to notify law enforcement or the clearinghouse that a request for a flag record has been made. Is it school, hospital, detention facility, hospital, military, or morgue, hospital, secure detention facility, or secure correctional facility, or is it the school, daycare, or birth certificate agency? And the last one there, the school, if they're under 11, it's the school, the daycare, or the birth certificate agency shall maintain the child's records in its possession so that on receipt of a request regarding the child will be able to notify law enforcement. There are 5 domains of risk factors for youth joining gangs. Kind of talk a little bit about youth gangs for a few questions here. Which one of these is not one of the 5? Family, peers, ethics, community. Family, peers, ethics, community. Which one of those 4 is not one of the 5 domains of risk factors that for youth joining gangs? Just a few more questions in this section of juvenile offenders. This is TCO Course Guide 33.25. There are 3 important parts associated with youth gang involvement. Okay, which one of these is included in those 3 important points? The most youth are forced to join. Joining a gang is a permanent decision. The presence of multiple domains, as we talked about those 5 domains, the presence of multiple domains in a youth's life increases the likelihood of gang involvement, or all of the above. Okay, remember those 5 domains, which includes family, peers, community. Those are 3 of the 5, obviously. The presence of multiple of those on a child's life would most likely increase the likelihood of them joining a gang. This is T Code 33.8. This is the Family Code 52.02. This is the way the question here is, except in the case of a child being taken into custody, and there are grounds to believe the child has been operating a motor vehicle in a public place while having any detectable amount of alcohol in the child's system, a person taking a child into custody without unnecessary delay and without first taking the child to any place other than a juvenile processing office designated under section 52.025 shall, which is the best answer, okay? Which is the best of these answers? And I can tell you all the above are not authorized options, okay? That's not the best answer. 1, release the child to anyone that will find the child a home for the remainder of the day. Bring the child to a detention facility within the jurisdiction of the juvenile court in the county where the offense is committed. Or if a school is in session and the child is a student, bring the child to the school campus to which the child is assigned if the principal's designee, or a peace officer who is assigned to the campus agrees to assume responsibility for the child for the remainder of the day. Except in a case of a child being taken into custody and there are grounds to believe the child has been operating a motor vehicle in a public place while having any detectable amount of alcohol in their system. In other words, unless you have them for DWI. Okay, essentially, unless you have them for DWI and you're taking them into custody, which again, and you're not going to take that person first take them into taking them into a place other than a juvenile processing. So if a school is in session, believe it or not, if they're a student, you're going to take them to that campus where they're assigned. If the principal's designee, or a peace officer is readily agreeable to assume responsibility. 33.9, Family Code 53.02. If a child is brought before the court or delivered to a detention facility as authorized by the Family Code sections 51.12A3 and 4, the intake or other authorized officer of the court shall immediately make an investigation and shall release the child unless it appears that his detention is warranted. A child taken into custody may be detained prior to hearing on the petition only if the child has only been convicted of a felony offense, the child has parents that are able to return the child to the court when required, or the child is likely to abscond or be removed from the jurisdiction of the court. Again, if a child is brought before the court or delivered to a detention facility as authorized by the Family Code sections, The intake or other authorized officer of the court shall immediately make an investigation and shall release the child unless it appears that his detention is warranted. A child taken into custody may be detained prior to hearing on the petition only if they are likely to abscond or be removed from the jurisdiction. Just a few more questions on juvenile. We'll wrap up this first study video. This is 33.13 your T code. This is Family Code 261.301. The department, and there's no other way to just read the question. The department shall make a prompt and thorough investigation of a report of a child abuse or neglect allegedly committed by a person responsible for the child's care, custody, or welfare. The executive commissioner shall, by rule, assign priorities and prescribe investigative procedures for investigations based on the severity and immediacy of the alleged harm to the child. The primary purpose of the investigation shall be the protection of the child. The goal is to protect the child. Rules must require the department. Rules require the department, or must require the department, subject to the availability of funds, to do what? Again, I want to select the best answer. To immediately respond to a report of abuse and neglect that involves circumstances in which the death of a child or substantial bodily injury of the child will result unless the department immediately intervenes. Respond within 24 hours to a report of abuse and neglect that is assigned the highest priority other than a report described by subdivision. Or C, respond within 72 hours of a report of abuse and neglect that is assigned the second highest priority, or all of the above. I would go with all three of those would be a good choice there. Be familiar with what a child advocacy center is. This is 33.16 excuse me, of your T code guide. These are specialized locations where agencies are housed to conduct investigations of child abuse and neglect, are referred to as child advocacy centers, or the CAC. We are very fortunate here in Tyler and Smith County to have a CAC. I was actually one of the founding members of the child advocacy, and was part of the folks that from the law enforcement side that created that system, modeled after many other agencies ahead of our time. But it sadly, it has grown exponentially, grown to the point that they have run out of the original building that they were in into the building there on Frankston Highway, to adding on, I see, and reconfiguring offices, and then they've got some portables outside. Hopefully soon, the Child Advocacy Center is going to be over on the East Loop, which will be nice there, in a very nice building, and with many floors there. If y'all have been in that building that are having dealings with them. So that's Child Advocacy Center. T code 33.18. This is the Family Code section 63.001, section 3. Basically, be aware of or know the definition of a missing child, which means a child whose whereabouts are unknown to the child's legal custodian and their absence is under certain circumstances. Okay, there's going to be four potential answers to this question. Which of the following is not one of the listed circumstances? Okay, which one is not one of those listed circumstances that classifies the person as a missing child? The child voluntarily left the care and control of the custodian with the custodian's consent and without intent to return. The child was taken or retained in violation of the terms of court order for possession of or access to the child. The child was taken or retained without the permission of the custodian and with the effect of depriving the custodian of possession of or access to the child, unless the taking or retention of the child was prompted by the commission or attempted commission of family violence as defined as Section 71 of the Family Code against the child or the actor, or the child voluntarily left the care and control of the custodian and the taking of the child was authorized by law. Which one of those is not going to be one of the listed circumstances? Where again, the missing child means a child whose whereabouts are unknown to the child's legal custodian and their absence is under certain circumstances. Which of the following is not one of those listed circumstances? And again, they voluntarily left the control of the care, custody, control of the custodian, and the taking of the child was authorized by law. two more questions in this section or this video. 33.22 of the T code. This is Code of Criminal Procedure 63.017. Talking about clearinghouse records that relate to the investigation by a law enforcement agency of a missing child, a missing person, or an unidentified body, and records or notations that the clearinghouse maintains for internal use in matters related to missing children, missing persons, or unidentified bodies are releasable or confidential. Again, we're talking about a child. So are they releasable or are they confidential? You have two choices. You're 50-50 on that one. And then the last question dealing with juvenile offenders and juvenile related stuff. Again, this is T code 32.23. This is the government code, GC, government code 411.355. On the request of a law enforcement agency regarding an abducted child, the department shall activate the alert system and notify the appropriate participants of the alert system, the appropriate participants in the alert system as established by rule in which of the following exists. If which of the following exist. Which of these would be things that trigger that notification? The local law enforcement agency believes the child has been abducted. The local law enforcement agency believes that the abducted child is in immediate danger of serious bodily injury or death or of becoming the victim of a sexual assault. The local law enforcement agency confirms that a preliminary investigation has taken place that verifies the abduction and eliminates alternative explanations for the child's disappearance, or sufficient information is available to disseminate to the public that could assist in locating the child, a person suspected of abducting the child, or a vehicle suspected of being used in the abduction, or all of those. And that should tell you, of course, the answer there. So those are about 40 some odd questions dealing with juvenile-related offenders. There'll be 3 more videos from this. There will be, again, one real quick one, about 20 some odd questions dealing with driving, and then the majority of the others are going to be dealing with patrol tactics, patrol procedures, which we're actually currently doing as I'm recording these videos, and coupled with radio communication. And then the 4th video is going to be deaf and hard of hearing, canine encounters, and then of course the filler questions to get up to 200 questions there. So I hope you enjoy. I know it's very boring, but I wanted to again give you all a chance to review, have adequate reviews. So you'll have these over the weekend, this coming weekend actually, to study for the test, which will be next week. Till then.